Welcome to our podcast. I'm Soojung Lee, Head of International Practice in Yulchon's Labor and Employment Team. And I have Chris Mandel here with me. Chris is a partner and a senior foreign counsel in our team.
Good to be here with you, Soojung.
The topic for discussion today is severance. It is a basic cost of doing business in Korea, but many of our clients, regional and global managers of foreign companies that do business in Korea, are often unaware how it works.
Right. Korean severance is unlike severance in many other countries. Let's briefly explain what that means for businesses with employees in Korea.
To illustrate how Korean statutory severance differs from severance pay in other countries, let's run through a few simple scenarios together. For those of you who are watching, see if you can guess which company has to pay severance in each case.
Okay. Scenario 1. Tam Cruz, bank manager, 5 years on the job. The company learned during a recent audit that he falsified expense reports and claimed unjustified expense reimbursements for several years. The company moves to terminate him. Scenario 2. Maddie Damon, salesperson at a software company, 3 years on the job. Pandemic-induced losses have led the company to conduct a workforce reduction. Maddie is deemed redundant. Scenario 3. Rafi Gadat, a hotshot game developer at an online game company. When she was recruited, she received a signing bonus of $100,000 conditioned on staying for at least 2 years. But she decides to resign after just over a year and take a job with a competitor. Scenario 4. Ok Jabong, head of a Korean branch office of an auto parts distributor. 6 months on the job, but it's not working out. The business is not performing as expected, and she's deemed a poor fit and targeted for termination. So, who's entitled to severance if their employment is terminated?
Okay, everyone, now pencils down. The answer is everyone, except the last one, scenario 4. And the reason is because in each case, except the last one, everyone worked for a company at least 1 year or more. And the reason for termination here becomes completely irrelevant. If you leave for a competitor, or if you become redundant, or even if you steal money from the company, as long as you worked for a company, at least for 1 year, you will get that statutory severance at the end.
This is sometimes a surprise to people from other countries who may assume that an employee who resigned voluntarily or was dismissed for cause would be ineligible for severance. You can think of severance in Korea as deferred compensation. The employee already earned those wages, and payment was just deferred until the employee leaves the company. So no matter how the employee leaves, that employee is entitled to receive the money earned. Now, let's take a closer look at our scenarios and explain some of the ins and outs. But before we do, how much severance do these employees get?
By default, severance is simply a lump sum cash payment. The amount is equal to 30 days average wage per year of service, prorated for partial years. As a rule of thumb, you can think of it as roughly equal to 1 month's salary multiplied by years of service. Determining an employee's average wage is where things can get complicated. Average wage is the base rate used to calculate severance. It is essentially all wages paid over the prior 3 months, divided by the number of days in that period, and adjusted for wages paid on a non-monthly basis, like certain annual bonuses. But there are complications. The most significant complication is what items of compensation are wages? Does it include profit-sharing bonus, performance bonuses? Much remains unsettled, and disputes over these issues are fairly common. A trend or direction is that certain items like performance bonuses that were traditionally not considered to be wages have come to be recognized as wages. But there are recent lower court decisions that have held that certain profit-sharing bonuses are not wages, and therefore will not be included in calculating one's average wage or severance. There is no established Supreme Court case on the issue yet.
And companies can also set up a so-called retirement pension to satisfy the requirement to pay severance. This can be a defined benefit pension, which has to pay benefits at least equal to the default severance pay amount. Or it can be a defined contribution pension, where the company has to contribute at least 1/12 of an employee's annual wages to the employee's account. But let's keep things simple and focus on the default severance pay system today.
Right. So back to scenario 1, temp cruise. Tem is our bank manager with 5 years on the job who falsified expense reports. As a side note, in Korea, even falsifying expense reports may not always be sufficient cause for dismissal. It may depend on the degree of losses to the company, the employee's motives, and other extenuating or aggravating circumstances. A simple tip to keep in mind is that it is just very, very difficult to lawfully terminate an employee in Korea. But assuming that Tam is validly terminated here, he is entitled to statutory severance pay because he has served for at least 1 year.
A question many would ask in that situation is, can we deduct the misappropriated funds from the severance pay amount?
And the answer is, no, you cannot. Setting off obligations against wages or severance is extremely restricted in Korea. In very limited circumstances, set-off is allowed, though limited in degree. A clear accidental overpayment of wages is one such situation. But simply owing a debt or a claim to the company is not one of those circumstances. So the severance must be paid in full, and the company has to seek recovery of its losses separately, unless the employee specifically agrees to set off as a part of settlement.
Moving on to scenario 2. Maddie Damon, salesperson at the company for 3 years, but targeted for redundancy. Redundancy is very tricky in Korea. Downsizing is typically achieved primarily through paying employees to resign through an early retirement program or similar program that goes by many names. Involuntary layoffs due to redundancy are subject to very strict statutory requirements and are generally reserved for companies in serious trouble that have to resort to layoffs after other efforts to save the company have failed. But whether or not this salesperson, Maddie, takes an exit package offer and resigns, or is actually dismissed under the strict statutory requirements, the employee would be entitled to severance due to his tenure of 3 years. The company's financial problems don't offer any justification to reduce the amount of severance. And employee severance is preferred over almost every other kind of claim that the struggling company may owe to its creditors.
Now, scenario 3, Rafi Garot, our game developer, recruited just over a year ago with a sizable signing bonus. And the bonus condition says that if she leaves before completing 2 years, she has to pay back the entire signing bonus. Her contract also has 1 year post-employment non-compete clauses.
So by now, everyone watching knows that Rafi is entitled to severance, even though it's her own decision to leave the company, and the reason is to join a competitor in violation of her contract. But is this one of the situations where the company can do a setup? Can the company set off the signing bonus that needs to be returned against the severance payment?
And the answer is no, it cannot, again. To be clear, there can be disputes over whether a signing bonus can be clawed back at all. Those disputes will turn on the precise contract language used, as well as other circumstances. But even if it can be clawed back because the clause is enforceable, it cannot be unilaterally set off against the severance or other wages owed to the employee.
And what if the employee's contract specifies liquidated damages or contractual penalties for violating the obligation not to work for any competitor for a year after leaving the company.
Well, in that case, the company can try to pursue legal remedies in court. How enforceable the non-compete clause may be is another matter that we can discuss for another hour. But the severance still gets paid in full.
Now, moving on to our last scenario, number 4. Okja, branch office head, is to be let go because the business is not performing to expectations and she's deemed a poor fit. As Soojung mentioned earlier, even falsified expense reports might not be enough to always dismiss. So naturally, one might think that poor fit or lackluster business performance isn't enough, right? Well, here, the company has an additional ace up its sleeve. The branch head might not be an employee protected by Korean employment laws at all. If so, then none of the strict restrictions on dismissal apply, and it is essentially a matter of contract law. This kind of employee status issue can be heavily contested in disputes, and it will mostly be decided based on the degree of authority and autonomy the branch head has to run the business and manage his own work and his employees. But having a plausible argument at least places the company in a significantly better position to negotiate a reasonable exit arrangement or try to win in litigation. Not only that, non-employees also have no right to severance pay unless the company has agreed or provided for such severance benefits via company policy. So in addition to his short tenure, there is another potential ground for non-payment of severance in scenario 4.
So those are the basics about the severance we want to cover today. I hope it has been informative. If you have any topics you want us to be discussing in a future podcast, please feel free to send us an email and let us know. And if you have any questions about the contents of the topic today, or any other employment law related questions in Korea, please feel free to send us an email or call us, and we'll be happy to address them. Thank you.